YouTube. 10 years old. 10 years of obscure pop culture comedy in the forms of YouTube poop.
Hey, you!
10 years of AMVs. 10 years of internet celebrities.
Banking, extremely quick to anger.
You mean monkey?
Banking,
No, that's definitely a monkey.
banking.
Whatever.
And 10 years of controversy.
I want to say that you guys have ruined my life.
YouTube has had its good moments
I'm dressed too sexily and you don't like it? Stop oppressing me!
and its bad moments.
Fuck you to all you 13, 14, and 15-year-old fucking little kids who are telling me I need to fucking lose weight!
Of course, extended periods of time are what we call sagas. So strap in and revisit some of the most notable sagas to have occurred in YouTube since its beginning. Greetings, my friends, and welcome back to another edition of History of YouTube Sagas. Now, I mentioned how each episode is unique and special, and interestingly, this one will also stand alone when compared to my previous ones. But this one is special in the regard that this does not involve specific YouTubers or movements on YouTube, but involves YouTube itself. Before proceeding, I should mention I've taken a look at all the suggestions people have been leaving, and do not worry, I will eventually get to them all in good time. But before I get any more comments on when I plan on doing a certain topic that has been largely requested since the series got dotted on the map thanks to Thunderfoot in episode 3, well, I think I have an idea on how I might end this series. Well, I guess I can't say I will end the series permanently, since future sagas will happen. But I should mention, I will not do an episode on a saga until 3 years have passed after its end date. Oh, and I should mention I'm going to divide this series into seasons. Each season will consist of 5 episodes. Now you may be wondering why, as this one will have a second part to it. Well, I am feeling this one will be a bit boring for many of you, and in order to prevent legal fatigue, the next part is not going to come out until next season. However, I'm not going to start off next season with this one. It'll be something different. And I should also mention that, yeah, this is going to be the last one I make for this year, and Season 2 will not come out until either late December or early January. But do please check out my other stuff in the meantime. I plan on making other videos apart from this series, and I'm coming up with new ideas for new series. And I might make a separate video on that later. Oh yeah, and one last thing. If you're gonna ask a question to me, please make sure you have it set so I can reply directly to you. Otherwise, people have been leaving comments that I can't reply to, so please check to see if you have responding enabled. Otherwise, I cannot respond to you, and I will not. So you will be left in the dark. But enough about that banter. Let's begin discussing today's saga. As I mentioned, unlike other sagas I have covered, this saga concerns YouTube itself as a party. I am referring, of course, to the ongoing copyright wars that have been waged on YouTube since it was first launched about 10 years ago. Because many copyright wars have been going on simultaneously, for the sake of organization, I'm only going to focus on one case at a time rather than a general chronology of the events concerning YouTube. Anyway, as we all know, YouTube first went online in February 2005. In 2006, it instantly became one of the most popular websites on the web. Not only were people uploading videos of themselves or content they created themselves, but people began uploading TV shows, music videos, anime, movie scenes, movie trailers, and entire movies split up into different parts. It was only natural that this would attract the attention of the big media conglomerates. To my memory, the first time the issue of copyright on YouTube was raised came in either late 2006 or early 2007. 20th Century Fox and Viacom had discovered several users had been posting entire seasons of shows like South Park and The Simpsons on YouTube. As you could imagine, those videos were gone shortly after they had been discovered by their company owners. This propelled Viacom, particularly, becoming one of the most primary antagonists and most butthurt when it comes to their material being used on YouTube without their permission. They cast Sauron's eye on YouTube, who had just completed their merger with Google a few months earlier. During 2007, Viacom began searching YouTube for any and all videos containing content that belonged to them. This led them to file
over 9,000!
Technically yes, but more than 9,000 actually. The actual number was
100,000!
Yes, over 100,000 DMCA takedowns on YouTube videos were issued that contained material from Viacom. For those unfamiliar with Viacom, the company's head is Sumner Redstone. Viacom is one of the 6 corporations that controls more than 95% of the media in the United States. On television, Viacom owns channels like Comedy Central, Nickelodeon, BET, MTV, VH1, and TV Land, not to mention the sister channels of these networks alone. Viacom also owns Paramount Pictures, which controls MTV Pictures, Nickelodeon Pictures, Insert Pictures, to name a few. As you can figure out, they own a lot of media, which is not very hard for them to find 100,000 videos of their content being used without their permission. A little less of the 100 that were DMCA'd were not infringing, but they were removed anyway. In the next month of March 2007, Viacom sued Google and YouTube. This was the start of a very long legal battle between the two major companies. Viacom sued Google for $1 billion, which it claimed it deserved after the cumulative amount of views on its copyrighted material of YouTube totaled to roughly 1.5 billion views. Viacom then claimed this was enough for them to take a significant loss of money. Because of this, Viacom became the most reviled corporation in the eyes of most YouTubers. A year later, in early 2008, YouTube, in order to more effectively combat copyright infringement, set up its Content ID system. It archived most copyrighted content, and when a new video was uploaded, would be sent through the archive to see if there was an ID match. Now I should mention this was somewhat of a prototype, and the Content ID filter YouTube uses now is way more potent than the one they were using back then. Later that year in July 2008, during the discovery phase of the pre-trial hearing, the presiding judge, Judge Lewis Stanton, ruled in favor of Viacom, ordering YouTube to hand over the data detailing the viewing habits of every user who would ever watch videos on YouTube. While this raised an issue over privacy rights, Judge Stanton dismissed them as quote-unquote speculative, and ordered YouTube to hand over the documents, which amounted to over 12 terabytes worth of data. In Judge Stanton's interpretation of the Video Privacy Protection Act, YouTube was not legally classified as a videotape service provider, therefore its users' data were not protected under the Act. To some, it appeared Viacom scored a major victory. But YouTube got one thing good out of the pre-trial hearing. That being, the judge rejected Viacom's request that YouTube hand over the source code of its search engine, believing that it fell under the classification as a trade secret. Despite this, most YouTubers were not pleased with how the court ruled. So naturally, many users began an organized online protest right here on YouTube. The protest mostly consisted of users uploading videos under the name Viacom Sucks. But to some relief, later that month, Viacom and Google agreed to allow Google to anonymize all the data before transferring it over to Viacom. Like all court cases that are long and convoluted, YouTubers were left in the dark for another 2 years when another decision was made in June 2010. On June 23, 2010, Judge Stanton ruled in favor of Google on a motion for a summary judgment. The judge held that Google was protected by provisions of the Digital Millennium Copyright Act, notwithstanding evidence of intentional copyright infringement. Judge Stanton acknowledged that Google certainly knew that copyrighted material was being uploaded by its users, but it could not know which clips had been uploaded without permission from the copyright holders and which ones did not. He also said that mandating video sharing websites to proactively police every uploaded video would, quote, contravene the structure and operation of the Digital Millennium Copyright Act, end quote. He said this was evidenced by the notification regime specified by the Digital Millennium Copyright Act was effective, noting that YouTube had successfully addressed all of the 100,000 DMCA notices issued by Viacom back in 2007. Viacom's main argument was by comparing YouTube and other internet-based media sharing websites, such as the online site Grokster, which had previously been found guilty of indirect copyright infringement. This comparison was rejected by Judge Stanton, and this ruling also reversed a previous court order issued 2 years prior in July 2008. When word broke out how the court ruled, YouTubers rejoiced.
In the information age, content, in fact, all intellectual property is big business. With technology making professional and casual piracy easier by the day, protecting copyrighted material is harder than ever. Just recently, Viacom lost its 3-year-old $1 billion lawsuit against YouTube. Here are the facts of the case. Viacom, the company that owns Paramount Pictures, MTV, Comedy Central, Nick, BET, and a bunch of other networks, sued YouTube, which is owned by Google, for $1 billion in damages, claiming that YouTube encouraged users to upload Viacom's copyrighted material. The judge ruled in favor of Google, saying that YouTube is protected under the safe harbor provisions of the Digital Millennium Copyright Act because it instantly responded to Viacom's request to take down unlicensed content. This was a big win for online services companies like YouTube, Facebook, MySpace, and Yahoo.
The web is built on a fundamental theory of openness. So if you accept Cliff's suggestion, then here's where we end up. Every time you upload a photograph to Flickr, they're going to have to check in advance to make sure you haven't taken a picture of a copyrighted piece of art. Every time you upload something to eBay, they're going to have to make sure that that isn't a fraudulent or fake Gucci bag that you're selling. If you allow prior restraint in the way the web is built, then the Digital Millennium Copyright Act has to be thrown out, which, by the way, you can take that to Congress. You can make an argument that that law is wrong. But the way that the ruling came down, it was exactly within the spirit of the law.
What were they thinking? I mean, really, what were they thinking? I'm, of course, referring to the recent court case between crooks and jerks, which would be YouTube and Viacom. Viacom recently lost its billion-dollar lawsuit against YouTube, and rightly so. Indeed, it's amazing that Viacom even took it as far as they did. You see, there's this phase of the trial called discovery, which is basically where either side gets to subpoena the other for documents relevant to the trial, emails, that sort of thing. And if you read both sides of the documentation that comes out of the discovery, an interesting picture emerges in which it really does appear that this was the battle between crooks and jerks.
So, how did Viacom react? Did they accept the ruling and move on to what they were doing prior to February 2007? Not a chance. After the June 2010 ruling, Viacom immediately appealed, but it would be another 2 years before the courts would hand down yet another ruling. The appeal was argued before the United States Court of Appeals for the Second Circuit in August 2011 and was decided on April 5, 2012. Viacom primarily focused on the internal emails among YouTube employees who were aware of the infringement of copyrighted material, including specific instances which the court deemed would disqualify YouTube from safe harbor protections. The judges in this case overruled Judge Stanton's previous granting of a summary judgment for Google and held that, quote, a reasonable jury could find that YouTube had actual knowledge or awareness of specific infringing activity on its website, end quote. They added that contrary to the Ninth Circuit's dismissal of the Universal Music Group versus Shelton Partners case, note UMG for later, the right and ability to control infringing activity did not require knowledge of specific infringements, and so the case became eligible for a jury trial. However, the court upheld one aspect of Stanton's prior ruling. One of Viacom's key arguments was that 4 of YouTube's software functions relating to user uploads automatically disqualified YouTube from safe harbor protection. Those 4 things being playback, transcoding, thumbnails, and syndication. Fortunately, the appeals court upheld Stanton's ruling that thumbnails, playback, and transcoding were covered under safe harbor protections. There was not enough information on syndication to pass judgment on whether or not it fell under the protections of safe harbor. After this round in the courts, it was renewed for more appeals. This time the wait was not as long. Just 1 year later, in April 2013, Judge Stanton granted yet another summary judgment in favor of Google and essentially added the previous ruling that syndication was in fact covered under safe harbor, and added that YouTube had no actual knowledge of specific instances of copyright infringement of Viacom's works, and therefore they could not have, quote-unquote, willfully blinded itself. After this ruling, another appeal was in the works, but as of October 1st, 2015, there's no news on it. This case was the first and most notorious. Out of all the major media companies to file DMCAs against videos containing their content, whether it falls under fair use or not, is Viacom. This makes Viacom the most reviled conglomerate in all of YouTube. And who could blame the users of YouTube for this? But the next biggest conglomerate to earn the ire and animosity of YouTube users is NBC Universal. Now, unlike Viacom, NBC Universal, the overbranch, was not directly involved with most of the takedowns, but other companies under its wing. Like Viacom, NBC Universal is one of the 6 major conglomerates that control 95% of the media in the United States. NBC Universal's league of companies includes Universal Pictures, which controls Focus Features and Grammar Cry Pictures. NBC Universal also owns Illumination Pictures, Universal Home Video, NBC News, E!, Oxygen, Sci-Fi, USA, Bravo, and not to mention the various news and sports channels under its wing. It also controls the Universal Music Group. The Universal Music Group in particular holds 6 subgroups, and each of these subgroups have at least a dozen or so record labels attached to it. These include Capitol, Caroline, Def Jam, Island, and Republic. And that is not even scratching the surface of the other record groups that they have dedicated to country and Latin music. Just look at their Wikipedia page and you will see for yourself. So if you have a big music collection, whether it's CDs, vinyl, or even the modern digital iTunes library, chances are you own at least a couple of songs or recordings that are owned by the UMG or one of its subsidiaries. And of course, UMG began its own assaults on what it perceived to be copyrighted infringements on YouTube. This all began just before Viacom began its purge. In February 2007, a woman by the name of Stephanie Lenz posted a video to YouTube of her young children dancing around the kitchen to the Prince song, Let's Go Crazy. The video was not even 30 seconds long, and the background music was hardly audible. It was not until several months later, in June 2007, that UMG filed a Digital Millennium Copyright Act on the video, demanding that YouTube remove it. Soon after it was flagged, Stephanie Lenz filed a counter notification saying this was fucking bullshit and was covered by fair use. After 6 weeks of whatever YouTube does to determine these things, the video was re-uploaded. Now, this is where the YouTube users began to take the fight to the conglomerates. In the next month of July 2007, Stephanie Lenz sued the Universal Music Group for misusing the Digital Millennium Copyright Act for its own ends. In fall 2007, both Prince and the UMG announced its intentions to purge YouTube and other online video sites of all user-generated videos of Prince and other artists out of quote-unquote principle. Of course, this led to the condemnation of the UMG, as they would file numerous DMCA takedowns in bad faith without even considering if the content in question fell under fair use. The case was decided almost a year later in August 2008. The court ruled that the copyright owners of the material had to consider fair use before they issue a DMCA takedown. and so the court denied the Universal Music Group's motion to dismiss Lenz's claim, and additionally refused to dismiss Lenz's misrepresentation claim as a matter of law. The court further found that UMG's concern over the burden of considering fair use was needlessly overstated, as simple good faith was all that was needed for the consideration of fair use, and did not require a thorough investigation. Lastly, the court also explained that the liability for misrepresentation is necessary and an important part of balance for the Digital Millennium Copyright Act. Now, of course, all this legal struggle does not end here. It likewise turned out to be a long and tedious legal battle going on for several years. But fortunately, this case is nowhere near as convoluted as the one for Viacom and Google. Practically 18 months later, on February 25, 2010, the presiding judge issued a ruling which rejected most of the Universal Music Group's defenses. This included the claim that Lenz suffered no damages as a result of their takedown notice. But the court did suggest that at this stage in the proceedings, Lenz's damage appeared to have been nominal. 3 years later, in July 2013, the same judge denied both the Universal Music Group's and Stephanie Lenz's motions for summary judgments. As a result, the two parties have cross-appealed to the Ninth District Court of Appeals. And it was during this year that oral arguments were held on July 7, 2015. And then just 2 months later, on September 14th of this year, the Ninth Circuit affirmed the district court's ruling. It has not been confirmed if this case is still ongoing, but so far it's looking good for us users. And to that end, I dedicate this to Stephanie Lenz for taking on the Universal Music Group.
Congratulations! 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 Congratulations!
Congratulations.
Congratulations!
Congratulations! Congratulations! Congratulations!
Congratulations.
Congratulations!
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 But of course, not everything is still fine and dandy when it comes to the Universal Music Group and DMCA trigger happiness. Furthermore, many speculated that the UMG also abused DMCAs to minimize criticism of its artists. Supposedly around the same time that Stephanie Lenz's video was taken down, the UMG also filed a DMCA takedown of a video featuring conservative political commenter Michelle Malkin talking shit about rapper Akon. Now, I will treat you to another story. You see this guy? This is my man, Brandon Tenold. Okay, I do not know him personally, but he is my favorite film reviewer on the internet. To those of you who do not know him, he has his own channel on YouTube dedicated to the reviewing of cult films, both great and cheesy alike. Anyway, he too has some unfortunate run-ins with NBC Universal itself. Now, this occurred a year ago in October 2014. For once, he decided to do something special to commemorate the Halloween season. He decided he was going to review the entire Tales of the Crypt movie trilogy. However, he only made it as far as the first film, Demon Knight. Well, what I mean is, that is the only one that's still up. A week or two after uploading his review of Demon Knight, he tried uploading the next film on the list, Bordello of Blood. It was up for about 24 hours, then the bastards at NBC Universal took it down for copyright infringement. Because his channel had already been deleted before, although for different reasons, Brandon, out of precaution, decided to cancel the reviewing of the final film on the list, Ritual.
Oh man, another What Happened video so soon? What the hell's going on here? Alright, so as some of you probably already know, my Bordello of Blood review has been blocked. The video was up for about a day, but it is now blocked worldwide. I'm real disappointed by this development. I really wish there was some place where you could watch the video, like, say, for example, some place I put in the description below. Wink. But the point is, you can no longer watch it on YouTube. The other big implication of this is that this means that I probably won't be doing Ritual. I've had some copyright issues with Demon Knight as well. You can still watch that video, thankfully, but I've still gotten some copyright grief over that, and I cannot afford to get another copyright strike at this point. You know, I just got this new channel up and running. I'm about to start on That Guy with the Glasses, so I really need to err on the side of caution here.
Fucking A. Well, at least Brandon's precaution is still keeping his channel up and running. And Brandon, if you are somehow watching this video, I kindly suggest you save up some of that Patreon money, hire a lawyer, and get some legal advice in case this happens again. And with that, we are out of time for this episode. Once again, I stress this will be the last one I make until either late December of this year or early January of 2016. And the next one will start Season 2, but it will not be a continuation of the events discussed here, and that will be the one after that. When Season 2 starts, I will try to maintain a schedule of uploading the next one every other month. Again, I will be making more videos on other stuff in the meantime, and I encourage all of you to check them out. My next two planned videos are a top 10 list and probably another AMV. After that, I do not know. But anyways, stay tuned for Season 2.